Chapter 20, Part 5. Another law is ERISA, the Employee Retirement Income Security Act. Let me explain what brought this about. Years ago, it's not as common today, but years ago many employees had pension plans. These were plans where the employer would put a certain amount of money into a fund so that when the employee retired, they'd be able to get usually a monthly stipend as a pension. But many problems occurred as a result of this. One of the problems that occurred was a lot of times the employers were putting the money into funds that then busted, bad investments, and then there was nothing for the employee. Another scheme, I guess is a good word for it, that occurred was that a lot of the pension plans had provisions that required that the employee work a certain number of years continuously in order to receive the benefit. And it might be something like, let's say, 15 years. And I actually saw years ago had a client like this. And when you reached the 14th year, guess what happened? The employer fired you. So you weren't able to get into the pension fund. So Congress passed a law to try and fix some of those problems, and it's called the Employee Retirement Income Security Act, which empowers a branch of the U.S. Department of Labor to enforce its provisions governing employers that have private pension funds for their employees. It doesn't require that you have a pension fund, but it requires that if you do have one, you have to meet certain standards. One of the key provisions is vesting, okay, and that's what I was talking about before. Under ERISA, most programs vest after 5 years. So once you've worked for the employer for 5 years, you are entitled to a monthly stipend based upon the formula that's used for the amount you contributed. If you leave before the 5 years, you are entitled to get back whatever you have contributed into the fund. There's also another formula, I don't know if I have it here, that's an optional one that deals with a phase-in over a period of time, but it's very rarely used. Okay, unemployment insurance, something very common right now during the coronavirus, with what, about 10% unemployment now and rising. Okay, this is one of those programs that's a state-federal partnership. The federal government gives the states a certain amount of money to operate these programs, and the states contribute a certain amount of money, and most of it is governed by state law. The purpose of this law is to have some security for people who lose their jobs through no fault of their own. Okay, and if you lose your job through no fault of your own, there's usually a waiting period, and then after that waiting period of a few weeks, you're entitled to a weekly stipend. It's never as much as what your wages were, but it's meant to at least carry you over until you find work. So employers fund this program by paying into the unemployment tax at regular intervals. If the employer has too many successful claims made against them, then their amount of contributions goes up. So in order to be eligible, you have to be willing and able to work. Okay, so if you left the job and you now become physically unable or mentally unable to work, you're not going to qualify for unemployment benefits. In addition to that, you have to be actively looking for work, and you have to turn in records to the Department of Labor to demonstrate that you are actively looking for work, and you cannot turn down any reasonable job opportunity. That is something that would be comparable to what you did before. So if you're making $100,000 a year before, and you're offered a job making minimum wage, you can turn that down. Now, workers who have been fired for misconduct or who have voluntarily left their jobs are not eligible for benefits. Now, voluntary is an interesting word. If you quit your job, even though that might be interpreted as voluntary, but you had good cause, then you do qualify. So if you quit because your supervisor was sexually harassing you, and you reported that and nothing was done, then you quit for good cause and you are covered by this law and you can get the benefits. And if you are terminated and your employer says it was for misconduct and you disagree with that, you are entitled to go through some due process, which includes an administrative hearing before an administrative hearing officer and an appellate process beyond that. Another law that is important is COBRA, the Consolidated Omnibus Budget Reconciliation Act. And this law was meant to enable employees who obtain their health insurance through their employer to continue receiving that insurance for a period of time if they are leave their job. And leaving the job can be voluntary or involuntary. It doesn't matter. It covers you for, I believe it's up to 18 months. The only workers who are excluded are those who were terminated for gross misconduct. Now, you have 60 days from the time you're terminated to apply for or trigger COBRA. After 60 days passes, if you don't do it, you're out of luck. So many people don't need to do so because they go on to other jobs where they get insurance, or maybe they can go on their spouse's insurance. Okay, now one of the key things about COBRA that makes it not such a good thing is that you have to pay the full premiums for your insurance. What a lot of people don't realize is when you get your paycheck and it says that the employer took out $170 for your insurance for the month, that's not the full cost of your insurance. Your employer is paying a considerable amount, usually a lot more than that, to cover your insurance. So let's say the employer is paying $200 and you're paying $170. When you go on COBRA, you're paying $370. So it's a lot of money and many people can't afford it. All right, now there's a trick to COBRA. And that trick is this. Okay, suppose you're leaving a job and you expect to go to another job and you expect to go there and have your new insurance at the new job cover you before that 60-day period occurs. What do? Should you buy that 60-day COBRA insurance or not? Well, we used to advise our clients, don't do that. Okay, don't buy it for 60 days. Why? Because if you have a health claim during that 60-day period, you can apply for it during that 60 days and it is retroactive. So let's say on the 15th day you get real sick and have a appendicitis. You go to the hospital, you run up $20,000 in bills. You go and you apply for COBRA, it's retroactive, you're covered. Okay? If nothing happens during that 60-day period, you lucked out. You saved yourself the premiums for that 60 days. The key is to make sure that you're covered after that 60-day period if you can. But during that 60-day period, don't pay unless you have a claim that you need to. Okay? The policy has to be kept active for up to 18 months, 29 months if the worker is disabled, and the coverage has to be the same as provided to the worker prior to the worker's termination of employment. Okay, that finishes part 5 of chapter 20. The magic word for chapter 20 is discharge.